Hi everyone, my name is Kyla DeBallis, and the case that I will be discussing today is a man by the name of Dan White. Now, before I get into the case, I just wanted to go over a few basics. Dan White had worked for the mayor George Moscone of San Francisco, where he was elected the position on the Board of Supervision, where he worked until he was sentenced to involuntary manslaughter. Some basic facts and information about Dan White. Dan White was born and resided in San Francisco, California for all of his life, where he had raised a family of three children with a woman, his wife, by the name of Mary Ann Burns. He had two sons and one daughter. His sons' names were Charlie and Rory, and his daughter, Laura. He was born on September 2nd, 1946, and he died on October 21st, 1985. His official birth name is Daniel James White, and before Daniel was elected the spot as a supervisor on the board, he also served the city of San Francisco as a police officer and firefighter. He also was a Vietnam veteran who, of course, was retired. Now, going further into the case off of the basics that I just stated, again, at this point, Dan was working as a supervisor on the board for the mayor, George Moscone of San Francisco. On November 10th, 1978, Dan had stated that he was depressed and frustrated. This was due to the reason that he felt that he had worked countless amount of hours, and so did his wife, and he felt he could never see his family, and he was not making nearly enough money to support his family for the hours that he was putting in, which caused a lot of frustration. So, continuing, George Moscone had agreed to restore White's position after Dan had agreed that this just was not the place for him. He resignated his term and his job, and he just thought that it wasn't the best fit for him anymore, as it was just deterring his mental state due to the reason that he just was putting in so many uncountless hours and he wasn't making enough to support his family. He felt that this was the best decision for him. He later realized that it obviously was not, so when he tried to get his job back, a lot of controversial came out from the public against the mayor, George Moscone, because the entire public felt that the only person who thought that he belonged on the board was Dan White himself. Nobody else agreed with that decision except for him. So, with this being said, George had no choice but to resignate his term and his spot on the board permanently and indefinitely. So, once Dan gained knowledge that he was not getting his job back, it just got worse from there and his actions spiraled. On that day, the same day that he heard that the news got released, Dan White had went down to the office where he worked, and he went directly into Moscone's office where he shot him 4 times at close range, twice in the back of the head and twice in the chest. Following the shooting of from Dan White of the mayor, George Moscone, he also had taken the keys that he had access to because he worked as a supervisor in the office, which he still should not have had any access to after his job was terminated. But Dan had used those keys to enter the supervisor's office where he had seen Harvey Milk, who he had also worked with, who was another supervisor on the team. He had shot him 5 times, 3 in his body and 2 shots in the back of his head once he was already down. A little bit more of the murder case continued. Harvey Milk, as I stated, was a supervisor that also worked on the team and the board with Dan White. Initially, there were allies on the team. They worked together, but the problem is that they both had 2 different political viewpoints, as Harvey was the first gay member on the board. So White basically had come up with a proposal opposing any and all job offerings to any gay or homosexual members, which is where the conflict had come into play between the two of them. White had admitted to the murder of both of the men, and in his statement, he had explained that he was mentally unstable for the reasons being, as I stated, that he cannot support his family, he could not please the public, and or his family. Dan White was originally charged with 2 counts of premeditated and deliberate murder, for which he could face life in prison or the possibility of the death penalty. But only a few months later, that initial ruling was terminated and looked into. As I stated, that sentence was reduced, but I'll get into that later. White ended up only serving 5 years in a 7-year sentence in the Soledad State Prison. Important theories in this case. The Twinkie defense. So the Twinkie defense, in theory, is basically the amount of sugar consumption that is supposed to alter someone's mental state. In White's case, the consumption of too much sugar causes the defendant to act out in murder of, again, the San Francisco mayor and another supervisor, Harvey Milk. This defense is legally considered a myth. The defense presented evidence that Dan White was indeed suffering from a mental illness, which was depression, but it was not led by the Twinkie defense. The amount of sugar consumed did negatively affect his mental state, as it was proven. In Dr. Martin's blind testimony, one of the 5 experts present for this case had later told the jury that White's consumption of junk food was not only a symptom, but it was an exaggerating factor in his depressed moods. What this means is this Twinkie defense, this is not the reason for his actions, but it did play into why he was mentally unstable. This theory was not pushed by the courts, it was pushed by the press, but the courts had nothing, there was nothing they could do except come to terms with it and reevaluate the decision made by the courts. Dan White's charges were brought down, and he avoided 2 counts of first-degree murder and premeditated murder because of the reason that he was he had a bad mental state, and he was convicted of involuntary manslaughter after his lawyers convinced jurors that eating too much junk food had diminished White's mental capacity. The Twinkie defense was repeatedly tried in the future by many other convicted criminals, although it was considered to be a myth. And again, White's attorney presented psychiatric and psychological testimony from 5 different mental health experts who all agreed that he was suffering from depression. This is not because of the Twinkie testimony in defense, but the consumption of junk food could have altered his mental state, but again, not causing him to act out in the behaviors as murder. The only other expert reference to White's junk food consumption was from the prosecution's sole expert, Dr. Levy, who not only denied White suffered from any mental illness at all, but he debunked any notion that Twinkies and other types of junk food could have basically altered his behavior, which deemed him as guilty. But nobody really listened to this. Also, Douglas Schmidt, White's lead attorney, told the jury that White was guilty, and the only issue was that he was not being responsible for his actions, and that he's unsure on how a relationship between sugar and violence can be brought out. Again, as I stated, someone being in a depressed state would mean that their mental health is not 100%, but there's no correlation between the amount of sugar intake and violent acts and behaviors. Another important theory discussed was the diminished capacity theory, and that is that a person, due to certain circumstances, in Dan's case, his depressed state, would not allow him to be able to premeditate at his actions as such as murder. It was argued by the court that he would have been unable to premeditate the act of these 2 murders, and Dr. Martin Blinder gave the most compelling and most controversial testimony in support of the diminished capacity defense. It was his defense that brought on the Twinkie defense by the public, and it was that defense that testified that White suffered a manic depressive syndrome dating back to adolescence, which was claimed to be the reason for White's altering eating disorders with the bigger consumption of junk food, which again caused for major depression. But in no relevance does this bring out violence behavior. It can cause major depression, but no correlation of violent behavior. both theories stand by Dan White's claims support his state of having a mental health illness, which is why the courts had to consider these theories. Evidence to support Dan's case. After hearing the news of being denied his position back, White made an appearance at the city hall where he worked, where he was able to access both George Moscone and Harvey Milk's offices. But to avoid metal detectors, he had entered the city hall through a basement window, which is clear justification that this indicates clear suspicious activity, which is evidence in itself. Also, not to mention that soon after Dan had shot these two men, he had called his wife from a payphone and had told her that he needed to meet with her to discuss what had happened, which is when they both went down to the nearest police station and he had confessed, which is also the most evidence that you need in the case. An autopsy also reveals that both of Moscone's head wounds were inflicted at a distance of about 12 to 18 inches as he was already wounded, which indicates that it was a very close shot. Dan White actually used his own keys, as I also stated, which means that he still had possession of these keys after his job was terminated, which he should not have had any access to, and that was the only way that he was able to access Harvey Milk's office. A few hours following the crime, as I stated already, he had discussed what he had done and walked to the nearest police station where he had surrendered and gave his statement. The final ruling. After nearly 6 days of heated deliberations, the jury had concluded that in the killing his colleagues, White had demonstrated neither malice or non-premeditation in deliberation, as I had also said, and this is how the 2 counts of murder had got brought down to a count of involuntary manslaughter. The final result, White eluding from the possibility of the death penalty and life in prison, where he only served 5 years. In the eyes of many, Dan White had gotten away with murder. 2 years following his release on October 21st, 1985, at his home in San Francisco, it was recorded that White had committed suicide. He attached a garden hose onto the exhaust pipe of his car, in which he had sat in a closed garage until he died. The case of Dan White still lives on to this day and is recognized by hundreds of people around the world, including other criminals and defendants who try and use the same Twinkie plea as Dan did in his case. As I stated, Dan's initial charges was 2 counts of first-degree murder that were brought down to a count of voluntary manslaughter, which is how he only served 5 years in prison. Critical evaluation of conduct of the criminal justice system. During the cross-examination completed by Dr. Levy, he had stated that he did not do a complete investigation because he wasn't asked to. With this being said, all proper precautions should have been taken in this trial in order to get full closure and results of the case. With this being said, if that was done, maybe the results and the final sentencing of this trial would have been differently and would have been left how it was, as 2 counts of murder, which is what it should have been. Also, the Twinkie defense. The Twinkie defense is considered to be a myth, and although it was brought up by the public, it was still brought into question by courts, which should not be allowed. Any type of theory that is a myth should not be able to sway the court's decision at all, and this is the reason why people believe that Dan got away with murder and only had to serve 5 years in, again, the jail. Possible application of information to improve the criminal justice system. Running a full and complete cross-examination is a given. In any case, especially murder cases, a full, complete examination should be fulfilled in all areas that are required in order to be able to, again, get the final rulings and callings of what actually happened in the case, not including any use of evidence relating to mythical theories. Mythical theories are theories that are legally not proven or not valid by the courts. So with that being said, for these theories to even be brought by the public and be able to be used to sway the court's decision should not have been allowed at all. And again, isn't kind of the reason that Dan White was let off with only a count of involuntary manslaughter rather than 2 counts of murder because of his depressed state, which, yes, Dan was suffering a depressed state, but there's, again, no correlation between the amount of violent behavior and sugar consumption, which should not have even been a thought in the court's minds. But again, because it was brought up by the public, it was. Here's a few pictures of Dan White. Here's Dan White and his wife and his family. Let me move this so you could see. And here's my works cited. Thank you guys for listening.